Sareta Ashraph, welcome to the program. We should note that you have not seen the interviews in question, but that we did send you detailed lists of allegations that both women made in advance of this interview. So, firstly, Mr. Khan has given several media interviews and public appearances in recent weeks, speaking also about this subject. But when we invited him onto the program, we were told, quote, it would not be appropriate at this time. Why is he not able to join today and you are the one joining us?
Well, thank you for having me here. When Mr. Khan spoke to the media, it was after the delivery of a report of a panel of judges, an independent panel of judges, who reached a unanimous determination that the evidence did not establish misconduct or breach of duty on the part of Mr. Khan. At that point, we thought the process would move forward as it ought to have moved forward, with the Bureau accepting the recommendation of the panel of judges that it itself selected and appointed, and to move to close the matter. It was at that point that Mr. Khan, who had not spoken throughout the entire process, came out expecting the matter to be moved towards closing. It has now become clear that that is not the path that this is taken in what I would consider to be an extraordinary step. A subset of 13 states in the Bureau has refused to accept the ruling of the independent panel of judges and has reached the diametrically opposite conclusion based on the same evidence. And so the process is now still ongoing. As a result, there are many legal issues that I hope that we'll be able to cover in this program. As Mr. Khan's lawyer, I will be addressing those.
Yes, and I'm specifically going to ask you to address some of the allegations, and you have seen a long list of them, very detailed list of allegations, and we have addressed them in our interviews with the two women as well. But let me ask you this. Yes, the panel of judges said, as you said, but also the other investigative body, the OIOS, suggested that actually there had been misconduct, and a number of members of the states did recommend that he be suspended pending another vote, which will be on July 24th, with all these member states. So let's just make that absolutely clear that he is suspended currently pending the conclusion of that vote. But victim number one, she alleges an escalating pattern of behavior, including non-consensual groping and penetration, including while she pretended to be asleep. To all intents and purposes, she says she was asleep. She also said that due to the power differential between her and her boss, Mr. Khan, any sexual relationship could not have been consensual. What is your response to this?
First of all, we would like to say that these are serious allegations, and they needed to be taken seriously, investigated seriously, and undergo a serious judicial review. And that is what has happened. The allegations that are presented in your program are not new allegations. They are allegations which form part of a much larger body of evidence. Mr. Khan has denied and continues to deny them in their entirety. Any form of sexual contact relationship, consensual or non-consensual, with the complainant. In this particular case, I also want to emphasize, you said at the beginning that the OIS report had made factual findings, and this differed from the panel of judges. One thing I want to make really clear to your viewers is that the OIS report does not have the same standing as the panel of judges. What OIS does is it's an investigative body. It investigates all of the allegations. It assembles all of the facts. It does not apply a standard of proof. And so it gathers a large collection of facts. In that, it presented a number of conflicting narratives. The judges themselves stated very clearly that the investigators in this case either did not reach conclusive factual findings or concluded that making such findings was impossible based on the evidence that they had collected. And indeed, the judges themselves found that the factual evidence gathered by OIS did not establish misconduct or breach of duty. In this particular case, this should not be presented as a he said, she said situation. OIS spent 13 months investigating this case. They interviewed over 30 witnesses. They collected over 5,600 pages of material, including telephone records and messages records. And from that, they produced a large number of conflicting narratives in their report. Of those narratives, you have presented to your viewers simply the narratives of a complainant VO1 and witness VO2. But in fact, the picture is far more less clear than is being presented. You're looking at a very small sliver of evidence against a much larger body of evidence, all of which the judges took into account, and the judges the ones who applied the standard of proof before reaching a finding that the evidence did not establish. The facts found by OIOS did not establish misconduct or breach of duty on the part of Mr. Khan.
As I said to you, and as you know, because we presented you with detailed, results of our interviews, we used a lot of the evidence that you all and Mr. Khan also delivered. So let's just be very clear about that. I would like to ask you about this. In the OIS report, there's testimony from a witness that she said she had thoughts of harming herself and that she had told this to Mr. Khan. What is your response to that?
With regard to that allegation, no medical evidence was presented to OIOS. Mr. Khan does not recollect ever being informed of that. But certainly if there were fragilities, if there were mental health concerns or vulnerabilities of particular individuals, that may have been the case. We obviously can't speak to someone's mental health, but certainly that did not result from any conduct on the part of Mr. Khan.
She described an atmosphere in which many people in the office were intimidated by Mr. Khan, saying that he would fly into rage, sometimes about social media posts. What's your response to that?
I'd say I myself have worked with Mr. Khan. That does not paint a picture of the man I know. I would also say that in the course of collecting information, OIS collecting information, numerous people who had worked with Mr. Khan came forward to speak of his supportive working relationships in the office on the teams that he'd done. More people would have come forward had the OIS investigator indicated that such character evidence was actually not useful to their investigation. Even in the case of the ICC, numerous people moved with Mr. Khan from previous employment to come to the ICC to continue to work closely with Mr. Khan. So again, I appreciate that is the evidence of one person who's spoken to you into this program, but there's a much larger body of evidence in this case. And if one steps back and looks at the entirety of the evidence, as we think it's reasonable and fair to expect that people should do, it paints an entirely different picture than what has been presented here today.
What about the second accuser, who in public has been called in another media operation, Patricia, alleging that approximately 16 years ago, when she was an intern for Mr. Khan, that he subjected her to sexual harassment, she says, constantly coming on to her, trying to get her to engage in intimate activity, also alleging that in the years between her allegations and the witness who we're talking about, the main witness, Mr. Khan, or rather the main victim, Mr. Khan has only become more powerful and emboldened and accustomed to more and more impunity, meaning that bad behavior unchecked simply has gotten worse. What is your response to that?
Again, these are not new allegations. These are allegations which form part of the investigation that OIOS did. Mr. Khan denies them in their entirety. In the case of this particular individual, she kept in contact with Mr. Khan for many years after she exited the world of international criminal law with a very positive relationship for a very long time. So we deny these allegations in their entirety, but they're also not new allegations. They're allegations which have formed part of the evidential record and which were seen alongside the evidence of over 30 other witnesses, as well as the evidence of Mr. Khan himself. And the complete evidential picture paints a far different picture than there's been presented here today. There is a reason why 3 eminent judges spent 3 months going through a massive evidence, including not only the testimony that was presented by VO1, the complainant, and by Patricia, but also evidence presented not just by Mr. Khan, but by 30 other witnesses, some of whom directly push back and contradict the narrative that has been given in some cases, and many of whom provide information that indicate that it is, in the words of one of them, very highly unlikely that what has been described could have occurred as described. So it is a much more nuanced picture and a much whole picture. And essentially what justice requires, and what anyone who is faced with an allegation of wrongdoing would ask for, is that all relevant evidence be looked at and be assessed by independent judges. That is what has happened in this case. And those judges, after 3 months and with an 85-page decision, in which they provided that analysis, came out and said that the evidence did not establish misconduct or breach of duty on the part of Mr. Khan. I think that should not be forgotten, and it should clearly be underlined. What should also be underlined is that the complainant in this case has been heard, and she should have been heard. In the course of the 13-month investigation, Mr. Khan, and many others gave multiple interviews. They were allowed to adduce any evidence they wanted throughout the 13 months, and they had a free rein to be re-interviewed if they so wished. All the evidence, additionally, not even 2 months ago, the complainant made further written submissions and presented an independent expert report to the Bureau to consider. This was not shared, in fact, with the defence, which I consider to be a breach of process, but nevertheless she was given the permission to do that as well. So this is not someone who has been silenced, and of course anyone alleging any wrongdoing should not be silenced. But in coming here, that this foray into the media comes a week before the vote on the 24th of July. The evidence that is being presented, the testimony that is presented, is already before the states, along with a huge amount of other relevant information which has not been presented on this program. And so we are obviously concerned at the timing of this coming out. It does create pressure in an already an environment which has become more political than legal. The decision to come on and present one part of a very much larger overall picture risks putting a thumb on the scales of the 24th of July vote. That's something that we're very concerned about. We would hope that your viewers would understand and at least recognize that there is a huge host of evidence and information that the judges had access to, that we hope that the Bureau and ASP members will access, that simply the wider public does not.
You've just talked about the process, and you have complained about the process and expressed concern about it. So can I ask you then, you are in New York, where this vote that is going to take place will happen on Friday, the 24th of July. Have you or any of Mr. Khan's team, or he himself, been attempting to lobby or influence member states ahead of this vote?
I am in New York. We have invited member states who have any questions about the evidence to ask us about the evidence. One of the concerns that we have is that this is, as I said, is a huge evidential record, 5,600 pages. It is complex in the sense that one has to look at where the inconsistencies are, where the gaps are, and so forth. The states were on the ASP, who largely have not been involved in this process, barring the 21 states who are on the Bureau, were informed of the special session on the 18th of June. My apologies, on the 23rd of June. That has left them with less than a month in summer to go through the evidential record alongside their full diplomatic roles. Additionally, we say the resolution by 13 states in the Bureau's first non-consensus decision in its entire history, contains within it misunderstandings of the evidence, and I would say at least one glaring mischaracterization of the evidence. Now, if you know the evidence, those are not difficult to find. But whether states who have not been involved in the evidence, have not been involved in evidence review to date, can go through within a month that level of that many thousands of pages of evidence and identify those misunderstandings and mischaracterizations is unclear. So we are making ourselves available, not necessarily to lobby, but to allow them to ask us questions, to clarify the evidential record, because the truth is that they're having to do a tremendous amount of work in a very compressed time, and it is not clear how well they'll be able to do that given their other duties in the month that has elapsed between the special session being called and the vote being held.
Just a quick question for my knowledge. Is that part of the accepted process? Is it, I mean, are you okay to lobby? Can you send them whatever information that you're sending them? Has that been authorized by a responsible part of the parties of the state parties?
I wouldn't use the word lobby. As I said, we've made ourselves available if they have any questions to us about the evidence, given that they haven't been involved in the process so far, and it is a process that has generated a huge amount of documentation and reports. There's no bar on us reaching out to states. Obviously, we have to remain within confidentiality, so we'll only provide briefings or any confidential material to states that wish to speak to us. We're not turning up on doorsteps and demanding to see anybody, but certainly we hope that the states will really look quite seriously at all of the relevant evidence, and also look at how is it that a panel of independent judges spent 3 months looking at this evidence and reached one very firm and unanimous conclusion, whereas in the case of the Bureau, who, while I think diplomats have many sterling qualities, they do not have the experience, the expertise, the temperament, or the appearance of impartiality of those expert judges, how a subsection of states on that Bureau reached a diametrically opposite conclusion based on the same evidence. That is something that should be of concern, and it requires then states to go back to look at the judge's report, to look at the evidence, the underlying evidence, to look at the Bureau resolution and consider how has this rather unusual situation come into being. They have a month to do that. In my view, that is simply not enough time to do this properly, and therefore we make ourselves available. But yes, we are allowed to do it. They don't necessarily have to see us, but if they wish to see us and they wish to ask us questions.
Let me ask you finally, as you've said many times, Mr. Khan and you, his legal team, now denies any sexual contact with any of these women whatsoever. So is it his position, is it your position, that these women are both simply lying and they've made up everything that we have heard?
We don't take positions on the motivations of why people have come forward to give particular testimony. I think, however, it is quite dangerous just to assume that because someone who comes forward and makes an allegation that should not be reviewed, that should not be assessed, and that should just simply be accepted as true. No justice system in the world works like that. The question, for example, of the believed women does not suggest that therefore you don't need a justice system and you don't need an investigation. What that campaign was directed towards was ensuring that victims' voices were acknowledged, were recognized, were treated by respect in a transparent and reasoned process. That has happened. These are serious allegations. There has been a serious investigation. They have been taken seriously. But they do need to be appraised. And they do need to be set against the background of all other relevant evidence to see where they fit in and to see what is corroborated and what is not corroborated. In this particular case, there are numerous conflicting narratives, in some cases even internally conflicting narratives, which led the judges to say that they were first led OIS not to be able to reach any conclusive factual findings on the contested allegations, on the allegations made. OIS did not reach any findings. The judges then, applying a standard of proof, determined the evidence did not meet that standard of proof. So this is where we are at the present time, that the judges have indicated very firmly and unanimously that the evidence does not establish a standard of proof.
That's all I have for now. Do you have anything further to add?
I do have one thing I would like to add, which is that the promise of the IC, the promise of any court, if anyone is accused of wrongdoing before any court, what they expect is a thorough investigation and the review of all relevant evidence by expert, qualified, and impartial judges. That is what has happened here. Until March 9th of this year, that had been the process. On March 9th, the judges handed down their decision. At that point, the process moved in a very unexpected direction. And I think for all your viewers, I would ask them to consider two things. First is if you have been in court and the judge has handed down something saying that the evidence does not establish that you have committed any wrongdoing, if a political body were then to step in and say, well, hold on, we've decided we don't like what the panel of judges has come down with, we're going to perform a de novo assessment ourselves and come to the exact opposite conclusion, that would be something I think that would be concerning to everybody and would need a tremendous amount of diligence in looking at why that has happened. The second thing I hope your viewers understand is that in this program, they have been presented with the statements of two people, It's important that those people have been allowed to speak out. But ultimately, that is a very small part of the evidence that was put before the judges. A tremendous amount of evidence has not been shown in this program and was assessed and took 3 months to assess before those judges. So if you take a step back and look at the entire picture that was presented by the entirety of the evidential record, it shows a very different picture from the one that has been presented simply by two voices today.
Sareta Ashraph, thank you for being with us.
Thank you so much.